So, the Assisted Decision-Making Capacity Act of 2015 and the Decision Support Service. So, in this presentation, I thought it might be useful to run through some of the reforms which the Act introduces, and then to introduce you to the functions of the Decision Support Service. I'll say something about where we are on the pathway to implementation and how, in particular, I think that the Act might be of interest to or impact on your membership. So, its long title is this. This is an act to provide for the reform of the law relating to persons who require or may require assistance in exercising their decision-making, whether immediately or in the future. And it is an act. It's fully enacted, signed into law, approaching 6 years ago now, right at the end of 2015, but it hasn't yet been fully commenced, which means that a lot of what I speak about isn't yet operational. The anticipated go-live finally is targeted at the middle of next year. Commencement is a fairly simple further procedure where the ministers will sign statutory instruments bringing the rest of the Act to life. And the new framework that I will describe to you applies to adults only, so over the age of 18 years. You might be aware that in some other jurisdictions, or for the purposes of other pieces of legislation, 16 and 17-year-olds are a separate category, but this is entirely about those over 18. And these then are some of the key reforms. The Act abolishes the wards of court system, which you might be familiar with. So that's the very old statutory framework that exists under the Lunacy Regulation, Ireland Act of 1871. The Act also repeals an even older piece of legislation called, rather shamefully, the Marriage of Lunatics Act of 1811, which was a very old statute which prohibited wards of court from marrying at all. And that the section of our 15 Act which repeals that actually has been commenced, and that happened on the 1st of February of next year, somewhat in response to a constitutional challenge which has been brought by a man who had intended to marry, I think in 2019, and then the wedding was injuncted very dramatically the day before. An application for wardship was commenced, and he has brought a challenge to the whole wardship framework, and partly in response then the repeal of that 1811 Act happened a couple of months back. It means that a ward of court is not prohibited from marrying by virtue only of the fact that they are a ward of court. So when the Act comes to life finally, all current adult wards of court will have their cases reviewed by the Wardship Court. And our understanding from the Office of the Wards of Court is that there are approximately 2,150 adult wards of court at present. And we understand that the biggest single category of current wards would be older people with dementia of one form or another. So their cases will be reviewed by the Wardship Court, and they will transition out of wardship within at the latest 3 years of commencement. And all or any of those adult wards can actually apply to the court to have their cases heard. They don't necessarily wait to be reached within that 3-year period. They can ask to be brought up the queue and heard by the court. And the Wardship Court will, I suppose, hear about their current situations, assess their capacity within the meaning of this Act, and decide whether they are free to have their property and their decision-making autonomy fully returned to them, or whether they need to move over to one of the forms of support offered by the 2015 Act. Another important reform is the functional assessment of capacity and its establishment on a statutory basis. And that's a time-specific and issue-specific test of capacity, and I'll say a little more about that on the next slide. The Act also puts in place important new statutory guiding principles. It establishes a 3-tier framework for support, and that's completely new. New tools for advanced planning by way of enduring powers of attorney, which are somewhat enhanced under this Act, and advanced healthcare directives. And it establishes our service, the Decision Support Service, with a number of functions which I'll speak about. So if we turn next then to that statutory functional assessment of capacity, Section 3 of the 15 Act says that a person's capacity apostrophes in the wrong place. A person's capacity shall be assessed on the basis of his or her ability to understand at the time that a decision is to be made the nature and consequences of the decision in the context of available choices. So again, we see that that is time specific, issue specific, and that contrasts with the finding made in wardship that a person is of unsound mind, and that's sometimes described as the status approach. It's like a badge that says that's now the category that you're in. In wardship, you're declared to be of unsound mind and incapable of managing yourself or your affairs. And that's been described as a blunt instrument, so that you might be taken into wardship for one particular purpose, or in relation to a set of matters, usually of considerable significance. But the effect of being a ward of court is that your entitlement to take your own decisions in respect of a whole host of unrelated or even minor or routine matters is no longer yours. That is taken away from you, and that is the unfortunate aspect of wardship. There's no diagnostic criteria or threshold, noticeably. So incapacity under the 15 Act isn't in any way related to a medical finding. That contrasts with the Mental Capacity Act in England and Wales. You might be familiar with that act, which refers to incapacity deriving from an impairment in functioning of the mind or brain, I think is the wording. And there's no such link in this act made between a medical finding and incapacity. So I think the effect of that then is that with limited exceptions, the act isn't prescriptive about who may assess capacity. So I imagine it's still currently where a person's capacity is in doubt, the typical course of action is to consult with a consultant psychiatrist or somebody with an expertise in age-related cognitive impairment, or whatever it might be. This act, I think, makes capacity everybody's business, and we can say more about that. And this is the four-part test which the Act establishes on a statutory basis, so that a person lacks capacity if unable to do all of these. So thinking about a particular decision and the information relevant to making that decision, a person lacks capacity if unable to understand that information, to retain it for long enough to make a voluntary choice, to weigh up that information, and then to communicate the decision, and that means communicate with appropriate assistance if necessary. So that assistance ought to be made available. The fact that a person may require the interventions of perhaps a speech and language therapist or sign language or assistive technology or easy read versions of the information, whatever that might be, that the fact that those supports need to be made available are not indicative of a lack of capacity, and indeed those supports should be made available. Now, I've referred to this as the statutory functional assessment of capacity because the effect of this Act is to put into written black and white law what is already the standard at common law. So this four-part test that I've set out here was already articulated by the High Court some 13 years ago in a case which concerned a woman's capacity to refuse a blood transfusion. So Ms. Justice Lafoy in the High Court in 2008 set out these elements, and that has been the standard in common law since. So it's already with us, if you like, and you will see it also in policy, including the HSE National Consent Policy and indeed in Irish Medical Council guidelines. Just a word about the terminology which we're using. So relevant person is defined by the Act, and you'll sometimes hear us say RP. I'm afraid there's a world of acronyms under this Act. So the relevant person is that person whose capacity is in question or may shortly be in question in respect of a matter or more than one matter. And you will see there that B and C recognise again that time-specific, issue-specific approach, so that it's possible to be a relevant person at one time in respect of one decision, but for your capacity to be absolutely intact in respect of different matters. We're inclined to use the term decision supporter. That's not terminology that you'll see in the Act. We really use it for convenience, that we don't have to say 5 things every time, because these are the different sort of supporters that are provided for in the Act. And I'll come to those. It's the decision-making assistant, co-decision maker, and decision-making representative. Then the attorney, whom you might appoint under an enduring power of attorney or EPA, and an entirely new agent called a designated healthcare representative, who may be appointed under an advanced healthcare directive. Okay, these are the guiding principles set out in Section 8 of the Act. And again, the first of these is already the common law standard. So that's the presumption of capacity. Any adult is presumed to have capacity to make a decision unless and until the contrary is shown. It's with us already, and the Act puts that into written law. I think the Act is strong on this next principle, which is about supporting a person to make their own decisions as far as possible. I've mentioned already that importance of ensuring that tools for communication are available. The Act has that ethos of ensuring that people are participants in the decisions, in the decision making that affects them. An unwise decision does not mean that a person lacks capacity. Now, that's sometimes misleadingly shortened to the right to be unwise. In fact, what the Act says is the fact that you want to do something that seems objectively unwise doesn't mean that you lack the capacity to decide to do it. It isn't evidence of incapacity in and of itself. Now, it could be, if it's something very imprudent, very out of character, that might raise a concern. It might be a red flag. It might suggest that perhaps capacity is in question. If you're a very careful person before and suddenly you want to take all your money and do something that seems quite reckless with it, that may be something that would trigger an assessment of capacity, perhaps, but the mere fact of it being unwise doesn't mean that you lack capacity to make that decision. The Act talks about dignity, bodily integrity, privacy, autonomy, and the right to control over one's own financial affairs. And that's very much in keeping with the ethos of the United Nations Convention on the Rights of Persons with Disabilities. And that obviously is an international document which was ratified by Ireland over 3 years ago at the beginning of 2018. And that UN Convention and its committee have been very strong about the next one, which is about giving effect to past and present will and preferences. At the same time, an intervener, as defined by the Act, should always act in good faith and for the benefit of the person. And importantly, the Act makes no reference to best interests, and that's a standard which I think we'll be familiar with. In fact, you see best interests in the Mental Health Act, for example, and I think in other pieces of legislation and policy. But the Committee for the UN Convention has been very concerned to emphasise that best interests is no part of an approach to capacity and to supporting decision making, and they emphasise instead the idea of giving effect to will and preferences. So when we talk about decisions under the Act, what do we mean? Well, the Act, if you look to Section 2, which is where you'll find all or most of the definitions, defines decisions according to two categories. So you've got property and affairs, and you'll see there are all the things you might expect around the ownership and management of property, paying down debts, applying for benefits, and also personal welfare. Then there's the separate category of decisions, and that would include accommodation, education and training, access to social services and healthcare, and then that broad catch-all, other matters relating to the relevant person's well-being. Here we see the new three-tier framework of support. So this is where the Act is quite ambitious. In comparable pieces of legislation elsewhere, there's only provision for the top tier. In England and Wales, for example, they have the court-appointed deputy, which is broadly comparable to our decision-making representative. But this Act establishes three tiers. So at the lowest and least formal tier, you have the decision-making assistant. So it's the relevant person, himself or herself, who makes the appointment in this case. So this is where the relevant person whose capacity is or may be called into question appoints to support them, somebody known by them, somebody trusted by them, to help them gather up information, to understand information, and to communicate what they want to do in respect of a particular piece of decision making. Important to say that the relevant person is still making the decision. At this lowest tier, there is the least amount of formality in terms of engagement with the decision support service, but complaints about a decision-making assistant could still come our way. There's quite a bit more formality here at the middle tier. So co-decision making, as the name suggests, describes a process of joint decision making. So again, the relevant person selects somebody known to them in a pre-existing relationship of trust, and then sets out in a co-decision making agreement the decisions which they want to take jointly with that person. So thinking about the relevant person's capacity at this tier, what the Act has to say is that the relevant person, has the capacity to appoint a co-decision maker, and then acting jointly with the co-decision maker has the capacity to make the decision. And this requires certain capacity statements supporting documentation to be sent to us in the DSS in order for that agreement to be registered. And those are statements from a medical and other healthcare professional. So the Act, I think, has thought somewhat creatively about this. There's a recognition that it's not just the medical person who is perhaps best placed or exclusively placed to make a statement about capacity. There is a recognition that others in allied health may have a closer relationship, may be more familiar with the person's capacity. So this Act reaches out to those people in allied health in order to ask for capacity statements from them also. So this is where the Act is formal about who can provide an assessment of capacity. And at the top tier then, there is still a route to court. It's supposed to be as a last resort. The Act is quite strong on this idea of the least interventionist approach, the least restrictive structures. And that is the Circuit Court in this case. Wardship, as you will know, is largely administered by the High Court. The idea of the Circuit Court is that it's more accessible, it's regional, it should be more cost effective. And an application can be brought then by anybody with a bona fide interest in the welfare of the relevant person. In fact, the relevant person can be the applicant. So the application is brought before the Circuit Court, and the Circuit Court is asked to make a declaration about the relevant person's capacity in respect of a decision or certain decisions. And having made that finding, the court can then proceed to make the decision itself. That's open to the court to do so, and it might be the least restrictive thing for the court to make the decision if it's a once-off isolated decision. Or the court can instead appoint somebody called a decision-making representative. Ideally, that will be somebody, again, known to the person. The court has to place priority on pre-existing relationships. It has to consider the importance of sustaining those relationships. It has to take account of the wishes of the person. But if there's nobody in the relevant person's life who's available, willing, or suitable to step into this role, then in this instance and at this top tier, the court can come to us and ask us to nominate a decision-making representative from a panel, which we will maintain, and then the court may appoint them. So these arrangements are to varying degrees supervised by the Decision Support Service. The lowest tier, not so much, but the middle tier and the upper tier then is regulated by the Decision Support Service, so that the co-decision maker, the decision-making representative, must report to us, file certain reports and remain under our supervision, and all have to apply the guiding principles. Just briefly on advanced planning, enduring powers of attorney exist already. You may well encounter them, and they've been in place since 1996. So that if you have an EPA under the 1996 Act, that's still fine. Whether it's been made or made and registered, whether it's an active EPA or not. But if you make one after commencement of the 2015 Act, then you're making a 2015 Act attorney, EPA. And where they differ then is that new reporting requirements and supervision requirements apply. Again, in order to make or to have registered an EPA, certain capacity statements are required, again, for medical and other healthcare professionals. And a new complaints investigations procedure applies. In fact, we will be able to take complaints in respect of attorneys under the 1996 Act. It's really the only interest that we have in those older EPAs. Okay, and the other important tool for advanced planning relates entirely to treatment decisions, and that's the Advanced Healthcare Directive. Again, these exist already, but on a non-statutory basis. And the courts have made some comments to the effect that they are authoritative and should be respected, but they are now going to be put on a statutory basis. And like an EPA, you can make an Advanced Healthcare Directive when you have capacity, and it's that opportunity for your capacitus, it is a word, for your capacitus voice to speak when you have lost, if and when you lose capacity in the future. And the Act says that the idea of an AHD is that it enables you to be treated according to your will and preferences. It provides healthcare professionals with information about your treatment choices, I mentioned already that there is now an opportunity to appoint a designated healthcare representative, and that's somebody known to you whom you're appointing to ensure that people know about your Advanced Healthcare Directive and to try and ensure that it is understood and respected. The Act states that a refusal of treatment made in an Advanced Healthcare Directive is to be treated as being as effective as if made contemporaneously. So if you state in your valid and applicable AHD that you don't want to be treated in X way, then that is as compelling as if you're saying it in the present tense with full capacity. And this can extend to and include life-sustaining treatment, but it can't include a refusal of basic care. So that you can't say in an Advanced Healthcare Directive, should I lose capacity, I don't want ordinary oral hydration or nutrition, I don't want warmth or hygiene measures. That is not something which can competently be put into an AHD. The Act does distinguish between requesting treatment in an AHD and refusing treatment. So that if you request treatment, that is certainly something for the healthcare professional to take into account and to apply if possible, and to record why it isn't being followed. But the refusal of treatment is mandatory in effect where this is a valid and applicable AHD. And there is a route to court for the court to determine, if necessary, if there's a question about validity and applicability. And I think important to say the Act also has certain protections for healthcare professionals who are dealing with an AHD or where they can't locate the AHD or can't locate it in time. Bit of a digression, but if I could mention what we tend to call the next of kin myth. There is an established belief abroad that the next of kin already has a legally recognised role as a decision maker, and this isn't helped by the fact that next of kin is a term which you still see routinely in official documentation. A person by virtue only of a family relationship does not have the authority to share information, to take decisions, to supply or withhold consent in respect of another adult. And that can come as a surprise to people. If you have appointed an attorney, talking about current law, if you have an attorney under an EPA, then they have whatever authority you've been able to set out in an EPA currently. Or if you are a ward of court, then the court. And to an extent, your committees appointed under wardship have a certain role. Beyond that, there is no legally recognised mechanism for one adult to take a decision on behalf of another adult. But lots of people think that that isn't the case. And I've set out the results of a 2018 survey which shows how widespread that belief is. I think what the messaging needs to be is that the 2015 Act isn't taking away something that has existed heretofore, and in fact it is supplying certainty and a known legal process where currently we tend to operate in a grey area really based on custom and practice. So the Decision Support Service, and that's our service, we are located within the Mental Health Commission, incidentally, and many of you will know that the Mental Health Commission has a whole other statutory remit to do with the regulation of acute mental health services. So this is quite new and quite different, but it's proved to be a good home because the Commission has that important experience of taking reforming legislation and building new structures. These are some, not all, of the Director's functions under the Act. Actually, this part of the Act has commenced already. So we have a job to promote awareness and confidence in the new framework, to provide information and guidance to organisations and bodies, to maintain searchable registers of arrangements. So we will have under the Act registers of those co-decision-making agreements, top tier, decision-making representation orders and enduring powers of attorney, so that it could be important for a clinician to know, okay, somebody here is calling themselves a co-decision maker. How do I know that? How can I check that they are properly registered, and indeed what is the extent of their remit under a co-decision making agreement? So we will have those registers which will be searchable by persons with a legitimate interest, and regulations will say also that they will prescribe for certain professionals or recognised bodies to be able to get into that register, and clearly that could be important. We will have, I've mentioned already, a function to supervise decision support arrangements. Patsy and Fiona here will be working in complaints and investigations. So yeah, I mean, somebody working in services or who is engaged with this new decision support arrangement could become aware that things seem to be awry, that perhaps this decision supporter isn't applying the guiding principles, isn't observing the will and preferences of the relevant person, or is overstepping the remit that the arrangement grants them. Then there could be an opportunity or a necessity for that clinician or professional person to report that to us by way of a complaint, and we have fairly extensive powers to take up that complaint. The director has a duty to support organisational change to promote the exercise of capacity. We will be setting up, I've mentioned already, the decision-making representative panel. There will also be, maybe of interest to you, a panel of special visitors, who will be persons who, in the opinion of the director, has particular knowledge or expertise in matters of capacity. And we will be calling on special visitors in the context of our supervisory functions, in the context of complaints investigations, where we need to understand what somebody's capacity is. And there will also be codes of practice. I think there are 15 codes in total. We may be able to reduce that number and collapse certain codes together, but yeah, there will be codes of practice to provide guidance to the relevant person, to their supporters, and to certain professionals. I find it's useful to say what we don't do, so that outside of our statutory remit are these matters. The DSS won't make decisions for people. In some other countries, the director of the decision support service is, no, because that term isn't used anywhere else, it would be the public guardian or public trustee or both. And they sometimes have, as a last resort, the job to actually be the decision maker. We don't. We won't directly appoint decision supporters. We don't have a function to manage people's money and property. There's a small subsection of the Act which says that we could, but we actually don't expect that to be part of the Act as it is commenced. We won't regulate and supervise other arrangements outside of the Act. What I mean there is that people currently have, I suppose, they have their support networks, they have ways of making their decisions, they have people who do that for or with them at the moment. I think it's, once the Act commences, it's opportune to look at all of those arrangements to consider whether they're compliant with the Act and whether, in fact, a new arrangement under the Act is required. But we can't know about those. We have sometimes encountered this apprehension that we're going to step into people's lives, that we're going to enter their homes and say, you're not doing that right. We won't know how people are living their lives currently or how their decision making is undertaken, you know, whether they're at home or in services or whatever they might be. But obviously we do have these regulatory functions in relation to what is done under the new framework. And we're also not the regulator of other professionals. So that if somebody, you know, has a complaint about how a healthcare professional is applying the Act, well, you have your own regulators already, and we may be called upon to provide some sort of intervention or education around the Act itself, but we can't take complaints. Okay, the codes of practice I've mentioned briefly, just to let you know what they will be. So there will be a general guidance code on supporting decision making and assessing capacity, one particularly for health and social care professionals. There will be codes on advanced healthcare directives. We may incorporate the one for healthcare professionals working with AHDs into that overall code. The status of the codes is as follows. The Act says that a person concerned shall have regard to a code of practice when performing any function under the Act, in respect of which the code provides guidance. A number of codes have been with us in draft form for some time, and they were composed by expert writing groups. And a public consultation will take place, so do please keep an eye out for that in the coming months before commencement of the Act. And then those codes will be published with the consent of the Minister, and they will be kept under review as well. And briefly then, where we are on the pathway towards commencement, because people are right to be impatient at this stage. This is an Act which is approaching its 6th anniversary. We used to belong to, if you like, the Department of Justice and Equality, and at the beginning of 2020 agreed a plan for commencement with the department so that our establishment project is well established and underway. Our design principles are that we are focused on a person-centred approach. We intend a digital-first approach. You might have more questions about that, but very much the learning taken from other jurisdictions was not to become wedded to paper-based or manual systems, but we accept that not everybody may be digitally connected or confident. We will be an outward-facing and accessible service. Communication and stakeholder engagement has been ongoing for some time. We speak to a huge array of people because this is an act which will have impacts across multiple sectors. Preparations for panel recruitment have commenced. We are no longer with the Department of Justice. We've moved to the new Department of Children, Equality, Disability, Integration and Youth. And as I mentioned at the start, the proposed go-live date then is in the middle of next year. The establishment of the DSS is only one part of the Act. So as you can imagine, other key stakeholders have their preparations to complete as well. One example would be the courts, who will be taking on a whole new area of business at the circuit court level. And also the Act itself, not to confuse matters further, will be somewhat amended before it's actually commenced. But that's a good thing. We've been looking at the Act, thinking about ways that it might be made work better. A lot of our submissions have been taken on board by our department, and we expect to see a number of minor technical changes, but some a bit more substantive. One of the biggest being, in fact, to improve the position of current wards of court in terms of their right of access to the court, to periodic reviews, to representation before the court when their wardship status is being reviewed. Okay, and I think this is, yep. Just some questions that we think would be useful to consider, and I've written these from the point of view of the person. So will I need access to the new supports under the Act? At present, how are decisions being taken? Is somebody taking my decisions for me, and can I make these for myself? Who can help me to make my own decisions as far as possible? Will I require a formal arrangement, and how can I engage with the decision support service to make such arrangement? Who might be available and eligible to assume a role in a formal arrangement? Yeah, because there are eligibility criteria, so that, for example, a provider of residential services or an employee or the owner of residential services can't step into one of these roles. Somebody who is also in a support arrangement can't be somebody else's supporter. That's there in the Act. Another question might be, do I need to consider advanced planning by way of an enduring power of attorney or an advanced healthcare directive? And for current adult wards, that 2,000 and some people, do I need to be supported, and how can I find support with the review by the wardship court? And how to find out more then, our website has been up for over a year now. We also do already have an information function. I think Patsy might be sending on our direct email address. So we get calls all the time about this. A lot of them aren't for us really, and we're able to refer them on because they refer very much to the present tense. How are things to be managed currently, pre-commencement of the Act? So we tend to send those elsewhere, but we're more than amenable to taking questions about the Act and our service. So I spoke for a bit longer than I'd intended to there. Let me leave it there, and we do have some time for questions. And as I think Patsy has said at the start, if we don't get to you or if questions occur to you afterwards, by all means do send them on. We have a frequently asked questions section on the website, and we endeavour to keep that updated and useful. So thank you very much.